Our appellate rules in Nevada, they spell out a list of types of orders that are appealable through a notice of appeal. These are detailed in Rule 3A. These generally are final orders, they're special orders after a final judgment, child custody orders, but it's a very specific list, and it includes some non-final orders as well. But those orders are the orders that you can appeal through a notice of appeal or a standard appeal process. Now, what do you do if you have an order that you want to appeal that isn't one of those orders listed in Rule 3A as being appealable? Well, there's two different mechanisms to address that. One, if you are appealing an order that's listed in 3A, you can include in your appeal other orders that are not specifically listed. So if you're appealing a final order and there were temporary orders that were entered throughout the proceedings, you can include those in your appeal of the final order as well. If you're appealing a final order and you want to appeal a related contempt order, even though that's not independently appealable, you can include it in the appeal of the final order as well. So that's one mechanism. Another mechanism is called a writ petition. They're called extraordinary writs. And a writ petition is asking the appellate court to go in and tell the district court, you have to do something or you can't do something. So the you have to is called a writ of mandamus. The other one, a writ of prohibition, is the one where you're asking them to tell them you can't do that, right? So writs, extraordinary writs, are they're either a regular writ, or we also have emergency writs, which have a little more expedited process for them to be reviewed. Now, a writ petition can be filed to review any type of order. So it can be filed to review a temporary order, and that's the most common situation for it. And if you have the ability to actually file a regular appeal, then most likely your writ petition is going to get denied because you have the ability to do a regular appeal. So it's not an alternative that you want to choose if you could do that or a regular appeal. It's something that you want to do when you don't have any regular appeal option at all. And so the most common scenario it comes up in family court proceedings is for asking for a review of temporary orders that are in place. And so if you have a temporary order that was entered and you're not going to have a trial, or you don't even have continuing proceedings in order to have it reviewed, something like that, you don't really have a speedy remedy of having your case actually heard to a final conclusion in the district court, then a writ petition can be a good mechanism to ask for review by the appellate court. Now, the thing to remember is that they're called extraordinary remedies because they're not granted very often. It's not something where the appellate court is going to go in and just insert their own opinion instead of the district court judge. It's going to have to be some major error made by the district court in order for the appellate court to make a decision reversing the district court's decision, basically granting the mandamus or the prohibition against the district court judge in that case.